Hi friends. So this is the fourth lecture of Professional Ethics, Accountancy of Lawyers and Bar Bench Relations, and I'm Lokesh Pathak with you. So as we informed in the previous class, which was class 3, which was related to admission and enrollment of the advocates as per Advocates Act 1961. So today we'll speak about the right to practice, which is mentioned in section 29 to 34, which is also called chapter 4 of Advocates Act 1961. So here in this section, in this set of sections, we'll talk about section 29 to 34. Now what section 29 says, which is a very important section because it says that advocates are only recognized class of persons who are entitled to practice the law. So it gives the advocates an exclusive right to practice because it is said that these are the only recognized class of persons who are entitled to practice the law. Section 30 says about the right to practice, which is the topic also for this discussion. Now it is divided into three sections. However, it says that every advocate who is registered in a straight role, he shall be entitled to practice where? First, in all courts, including Supreme Court of India. Second, before any tribunal or person who is legally authorized to take the evidence. Third, before any other authority or a person before whom he is by or under the law in force entitled to practice. So section 30, it talks about the right of the advocate, that he has a right to represent if he is enrolled in a particular state court or a role of a state, then he has a right to appear and he's entitled to practice in any courts including Supreme Court, then before any tribunal or any person who is legally authorized to take the evidence, and then also in front of any other authority or a person who is as per the law in force entitled to listen and entitled to make the proceedings. Section 31 was related to special provisions for attorneys, but it was omitted by amendment of 1976, so it is not in place. Section 32 says the power of court to permit appearances. In that section, it is said that the court is empowered to permit appearances in particular cases to any person who is not enrolled as an advocate to appear before it. So this gives the power to the court to allow a person who is not an advocate, but he can proceed with the proceedings. Section 33 again repeats section 29, but with a different graduation. It says that advocate alone entitled to practice. So while 29 says that advocate is the only recognized class of persons who are entitled to practice the law, section 33 says that advocates are alone entitled to practice, not in a form of army or something. So section 34 talks about the power of high courts to make rules regarding these conditions and any subject to which advocate shall be permitted to practice in high court and subordinate courts. So as per section 34, this power is given to high courts to make any rules with regard to the appearances of such advocates in the court. So if the question comes to right to practice, apart from the different case laws, we have to concentrate from section 29 to 34. Here we have seen that section 29 gives an exclusive right to the class of advocates which are entitled to practice the law. Then section 30 elaborates the right to practice in three subsections. It says that all advocates which are registered in a state role, they are entitled to practice in number one, all courts including Supreme Court of India, number two, before any tribunal or a person who is legally authorized to take evidence, and number three, before any other authority or a person who is by or under law in force entitled to practice. So this is section 30. Section 31 is deleted. Section 32 says that power of court to permit appearances to non-advocate persons also. Section 33 says advocate alone entitled to practice, and section 34 says power of high courts to make rules, and they are empowered to make rules and permitting the advocates to practice in high courts as well as subordinate courts. So with this small lecture, I would like to wind up, and now in the future lectures we will talk about the other important points which are left in this subject, which relates to the conduct of advocates. So what is the procedure of the punishment? Then in other lectures we'll see about the BCI rules of Bar Council of India, which are mentioned in part 6 of chapter 2 of section 1 to 6 of BCI rules, that also we'll see, and then we'll discuss about bar and bench relations, and afterwards the contempt of court. So with this, I would like to wind up this class. Hope you are enjoying the way it is being taught, and any comments you can make in the comment section. Thank you. Have a nice day. Bye.